Welcome to the Bar Exam Toolbox podcast. Today, as part of our Listen and Learn series, we're discussing the duty of candor. Your Bar Exam Toolbox hosts are Alison Monahan and Lee Burgess. That's me. We're here to demystify the bar exam experience so you can study effectively, stay sane, and hopefully pass and move on with your life. We're the co-creators of the Law School Toolbox, the Bar Exam Toolbox, and the career-related website Career Dicta. Alison also runs the Girls Guide to Law School. If you enjoy the show, please leave a review on your favorite listening app and check out our sister podcast, the Law School Toolbox podcast. If you have any questions, don't hesitate to reach out to us. You can reach us via the contact form on barexamtoolbox.com, and we'd love to hear from you. And with that, let's get started. Welcome back. Professional responsibility is a heavily tested topic. You will take the MPRE, which is all about professional responsibility. And if you are in California, you will likely see professional responsibility on your written exam as well. While it's not hard to understand, sometimes there are some tricky nuances in the professional responsibility rules. So let's start with the rule for duty of candor. Under the ABA, a lawyer cannot engage in conduct involving dishonesty or fraud. A lawyer cannot knowingly A. make a false statement of fact or law to a tribunal, B. fail to correct a false statement of material fact or law previously made to the tribunal by the lawyer, C. fail to disclose to a tribunal controlling legal authority known to be adverse, unless disclosed by opposing counsel, or D. offer or use evidence that the lawyer knows to be false. If a lawyer knows or learns he has offered false material evidence, including witness testimony, the lawyer must take reasonable remedial measures, including disclosure to the tribunal if necessary. A lawyer may refuse to offer evidence that the lawyer reasonably believes is false, except for the testimony of a criminal defendant. Note that in California, disclosure of confidential information is prohibited, absent consent of the client. This is important to note if you are studying for the California bar exam. Notice that right off the bat, the California law adds an emphasis on the disclosure of confidential information. Put another way, this rule allows lawyers to disclose falsehoods to the court as long as that disclosure does not run afoul of California legal and ethical duties of confidentiality to the client. California has updated this rule in recent years, so take note of that if you are reviewing professional responsibility sample answers from the early 2000s. The rule for duty of candor has gotten more detailed since then. Now, candor is not a word we use in everyday language, but it essentially encompasses attorneys' duty to be honest. It clarifies the line between offering statements or evidence that are knowingly false versus simply not disclosing facts that are less than favorable to the client. This nuance can be tricky. Facts that trigger this duty include those where the attorney has clear knowledge of the truth and then attempts to offer the opposite of that to the court, either through statements of fact or law or through witness testimony. It is important to understand that attorneys can have witnesses present opinion testimony that may be different from the truth, but if an attorney knows that a fact related to the case is true and offers false testimony to directly go against that fact, it could trigger the duty of candor. While lawyers have always had the ethical duty to tell the truth, this rule specifies when a violation can occur and gives attorneys a clear framework to work with. This duty also helps take some of the burden off the courts to investigate the truth, because when it comes to presenting a case, the attorneys are typically the experts on the facts and law involved. When presenting their cases to the court, having a standard of truth helps expedite the process of litigation and allows attorneys to have something to fall back on if their clients ask them to blatantly lie for them to the court. This rule also specifically requires attorneys to inform the court of any controlling law that is known to be adverse to their case. While this might seem like a broad requirement for attorneys in practice, it typically comes up when an attorney fails to cite controlling authority that is directly on point for their case, which might not be as often as you think. Opposing counsel will usually be quick to point out the adverse authority, so this requirement does not come into play as much as the other sections of this rule do. That does not mean it is not important. A duty to bring up controlling adverse authority is extremely important and is in the interest of judicial economy. If an attorney does violate the duty of candor, they are subject to discipline under the ABA and California rules and may be subject to withdrawal, depending on their jurisdiction's permissive versus mandatory withdrawal rules. An important part of this rule is that if attorneys are suspected to have violated the duty of candor, they have an equal duty to attempt to rectify the error, which we see in the rules as reasonable remedial measures. This provides attorneys with a chance to either quickly correct their false statement of fact or law, if they are in a hearing or during trial, speak with their client about offering truthful information, or investigate whether their witnesses will provide truthful testimony. This duty gives attorneys responsibility to be truthful, but also the autonomy to correct any errors, whether intentional or unintentional. Now that we have an understanding of what the duty of candor is and why it's important, let's look at some practice questions. Our first hypo is from the California Bar Exam, February 2018. Austin recently sold a warehouse to Beverly, the roof of which is made of a synthetic material called top tile. During negotiations, Beverly asked if the roof was in good condition, and Austin replied, "I've never had a problem with it." In fact, the manufacturer of top tile notified Austin last year that the warehouse roof would soon develop leaks. After Beverly bought the warehouse, the roof immediately started leaking. Beverly hired Lou, an experienced trial lawyer, and executed a valid retainer agreement. Beverly then sued Austin on the basis of misrepresentation and non-disclosure. At trial, Lou offered the expert testimony of Dr. Crest, an engineer who had testified in other litigation concerning top tile roofs. Lou knew that Dr. Crest had previously testified that top tile roofs always last at least 5 years. Lou also knew from the manufacturer's specifications that top tile roofs seem to last indefinitely, but not in some climates. On cross-examination, Dr. Crest testified that top tile roofs never last 5 years, and that climate is not a factor. Top tile roofs fail within 5 years everywhere in the world. During closing argument, Lou repeated Dr. Crest's statements. What, if any, ethical violations has Lou committed? All right, let's start off with the rule. Under the ABA, a lawyer cannot engage in conduct involving dishonesty or fraud. A lawyer cannot knowingly A. Make a false statement of fact or law to a tribunal, B. Fail to correct a false statement of material fact or law previously made to the tribunal by the lawyer, C. Fail to disclose to a tribunal controlling legal authority known to be adverse, unless disclosed by opposing counsel, or D. Offer or use evidence that the lawyer knows to be false. If a lawyer knows or learns he has offered false material evidence, including witness testimony, the lawyer must take reasonable remedial measures, including disclosure to the tribunal if necessary. A lawyer may refuse to offer evidence that the lawyer reasonably believes is false, except for the testimony of a criminal defendant. In California, disclosure of confidential information is prohibited, absent consent of the client. So first, let's address the issue as to whether Lou knew that Dr. Crest would testify falsely. Even though Lou is not required to disclose facts that are not helpful to his client, the duty of candor requires that Lou not offer evidence that he knows to be false or misleading. Here, Lou has demonstrated that he is an experienced trial lawyer who has worked with this particular expert witness before. The facts state that Lou knew Dr. Crest's previous testimonies involved characterizing the top tile roofs as lasting at least 5 years. Lou had also done the work of reviewing top tile's roof specifications, which indicated the roofs do not last indefinitely in certain climates. However, now Lou is at trial, and his witness testified differently than he has in the past. This tells us that either Dr. Crest has testified falsely, either in the previous trials or in Beverly's trial. If Lou knew that Dr. Crest was going to testify falsely, then under the ABA, he should not have allowed him to testify. However, if Lou reasonably believed he would testify truthfully, then Lou should have, at a minimum, tried to convince Dr. Crest to testify truthfully. Finally, if Lou knew that Dr. Crest had testified falsely, Lou is required to take steps to rectify the false testimony. Please note that in California, Lou would be required to disclose information sufficient to rectify the false testimony, so long as the disclosure did not violate Lou's duty of confidentiality to his client. So next, let's address the issue of Dr. Crest testifying that climate is not a factor. Lou's duty of candor toward the court forbids him from offering false material evidence to the court, including through expert witnesses. When Dr. Crest testified that climate is not a factor, Lou was aware of Top Tile's specifications that climate is indeed a factor. If Lou knew that Dr. Crest's statement was false, given Lou's research and Dr. Crest's expert opinion, Lou is required to rectify the false evidence. Lou also should not have cited this false evidence during his closing argument. Therefore, because Lou did not rectify the false evidence he offered through his expert witness and cited to false evidence during his closing argument, Lou is subject to discipline under the ABA and the California rules. The next hypothetical comes from the California Bar Exam in July 2014. Alice, a lawyer, represents Sid, a computer manufacturer. Sid sued Renco, a chip supplier, for illegal price fixing. Sid told Alice that he'd had enough of Renco setting the case's pace, so he wasn't going to appear at his deposition scheduled by Renco for the next week, and that he'd pay his physician to write a note excusing him from appearing. Alice did nothing in response. What ethical violations, if any, did Alice commit? As usual, let's start with the rule. Under the ABA, a lawyer cannot engage in conduct involving dishonesty or fraud. A lawyer cannot knowingly A. Make a false statement of fact or law to a tribunal, B. Fail to correct a false statement of material fact or law previously made to the tribunal by the lawyer, C. Fail to disclose to a tribunal controlling legal authority known to be adverse unless disclosed by opposing counsel, or D. Offer or use evidence that the lawyer knows to be false. If a lawyer knows or learns he has offered false material evidence, including witness testimony, the lawyer must take reasonable remedial measures, including disclosure to the tribunal if necessary. A lawyer may refuse to offer evidence that the lawyer reasonably believes is false, except for the testimony of a criminal defendant. In California, disclosure of confidential information is prohibited, absent consent of the client. First, we can establish that a deposition, which is under the penalty of perjury, holds the same weight as a tribunal, so the duty of candor applies to lawyers in depositions as well as in court. Here, Alice's client Sid blatantly told her that he was going to commit fraud by paying his physician to write a note to excuse him from the deposition. The duty of candor prohibits her from engaging in conduct involving dishonesty or fraud, including knowingly offering false statements of fact. Because she learned from her client that he was going to pay his physician to write a fraudulent note and did nothing to stop it, Alice has violated her duty of candor to the court. Alice may argue that she did not condone his actions, but Section A of the rule indicates that she cannot knowingly make a false statement of fact to a tribunal. By going along with her client's plan, while knowing the note was fraudulently obtained. Alice has violated her duty of candor to the court. Alice should have instructed her client not to pay his physician or should have told him that she cannot condone his actions and informed the court of the fraud. In California, she would only be able to take the remedial measures that do not violate her duty of confidentiality to her client, and most likely, Sid would not give his consent for her to share the truth. Therefore, under both the ABA and California rules, Alice has violated her duty of candor by failing to act after learning that her client was participating in fraud to get out of a deposition. Our final hypo comes from the California Bar Exam, February 2013. Carol, a woman with young children, applied to rent an apartment owned and managed by Landlords, Inc. Landlords, Inc. rejected her application, believing that Landlords, Inc. had rejected her application because she had young children. Carol retained Abel to represent her to sue Landlords, Inc. for violation of state anti-discrimination laws, which prohibit refusal to rent to individuals with children. Landlords, Inc. retained Barbara to represent it in the lawsuit. Barbara notified Abel that she represented Landlords, Inc. During a deposition by Barbara, Carol testified falsely about her sources of income. Abel, who attended the deposition, suspected that Carol was not being truthful, but did nothing. What, if any, ethical violations has Abel committed? As we noted on the previous example, the duty of candor applies in depositions, not just in traditional court. Here the facts indicate Abel suspected Carol was testifying falsely. Under the ABA, Abel cannot offer evidence the lawyer knows to be false, including through client's testimony. Abel has a duty to investigate whether or not the claims are false. If Abel knew that Carol's testimony was false, which it was, then under the ABA, he would have to take steps to rectify the falsehood, either by stopping the deposition and speaking with Carol privately and asking her to testify truthfully, or by refusing to offer her testimony at all. If Abel had a reasonable belief the testimony was false, he should have asked Carol to speak privately about the truthfulness of her statement and then tried to persuade her to tell the truth, which would be considered a reasonable remedial measure. In California, if Carol's sources of income were considered confidential, Abel would not be able to offer that information without Carol's consent. However, that would not permit Abel to offer a false statement in place of the truth. Therefore, because Abel was in a deposition where he has a duty of candor, and his witness knowingly testified falsely and he did nothing, Abel is likely subject to discipline under both the ABA and the California rules. A final thought on the duty of candor. This duty protects your credibility as an attorney. Your reputation and credibility go very far as an attorney. If you have good credibility, it's likely that you are looked at positively by your professional peers, clients, and by the courts you work in. Having credibility as an attorney means that you have integrity, you follow the rules, and you zealously represent your client. The duty of candor helps establish attorney credibility by emphasizing honesty, truthfulness, and openness toward the tribunal. It's not to say that you should not be strategic about what facts or law you use to represent your client, but it creates a baseline of behavior that allows you to strengthen your credibility, especially in the early years of working as an attorney while you're building your reputation. Remember, the duty of candor is just one duty in a long string of duties that attorneys have. If you are studying for the California Bar Exam, professional responsibility is one of the most heavily tested topics, so it's very likely the duty of candor will come up on one of your essays, even if the facts related to the issue are pretty short, like we saw in our hypos today. For all other jurisdictions, remember, you also need to pass the MPRE in addition to the full bar exam. And with that, we are out of time. If you enjoyed this episode of the Bar Exam Toolbox podcast, please take a second to leave a review and rating on your favorite listening app. We'd really appreciate it, and be sure to subscribe so you don't miss anything. We have future Listen and Learn episodes coming out. If you have any comments or questions, please don't hesitate to reach out to myself or Alison at lee@barexamtoolbox.com or allison@barexamtoolbox.com, or you can always contact us via our website contact form at barexamtoolbox.com. Thanks for listening, and we'll talk soon.